PTAB A Year in Review. Before I turn the presentation over to our speakers, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window, which is designated with a question mark icon. The PowerPoint presentation will be available on our website at Foley.com in the next few days, or you can get a copy of the slides in the resource list widget. As a reminder, today's program is being recorded and will also be available on Foley's website in the next few days. Foley will apply for CLE credit after the web conference. If you did not supply your CLE information upon registration, please send an email to Taylor Bannister at tbannister@foley.com. To be eligible for CLE, you will need to log into the On24 session and answer a polling question during the program. Please note certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. As a final note, those seeking Kansas, New York, New Jersey CLE credit are required to complete the attorney affirmation form in addition to the polling question that will appear during the program. The 5-digit code will be announced during the presentation. Please email the form to Taylor Bannister at tbannister@foley.com immediately following the program. At this time, I would like to introduce our speakers, George Beck, Andrew Cheslock, and Steve Mabius. George Beck is a partner and intellectual property lawyer with Foley & Lardner. He focuses his practice on patent counseling, procurement, and post-grant proceedings before the U.S. Patent and Trademark Office. Andrew Cheslock is a senior counsel and intellectual property lawyer with Foley & Lardner. He has extensive experience in patent litigation, reexamination, and counseling in the electronics and software fields. Steve Mabius is a partner and intellectual property lawyer with Foley & Lardner. He has led teams within Foley handling a variety of different kinds of IP work, including IP due diligence, licensing, litigation, reexaminations and interferences, as well as pharmaceutical patent term extensions. I will now turn things over to our speakers. Thank you.
Thank you, Taylor. This is George Beck. I'd like to welcome all the participants who are joining us today. Today we're going to first discuss trends and statistics relating to AIA proceedings at the PTAB. We will then provide a brief summary and update as to the oil states and SAS cases which were recently argued at the Supreme Court. We'll then discuss certain topics that we found of note from last year. These include changes to how the PTAB handles motions to amend, developments affecting motions for additional discovery, the PTAB's procedures for handling remands, developments in PTAB Appeals, trends and challenges filed by generic petitioners in pharma IPRs, and finally we'll discuss issues relating to attempts to avoid post-grant challenges based on sovereign immunity claims. First, I'm going to briefly discuss the trends reflected in some statistics. This slide that we're showing now reflects the number of petitions on a monthly basis that were filed through December of last year. The blue graph shows IPR petitions. As shown, while there was a few peaks in IPR filings, particularly in January 2017, the overall trend reflects a relatively steady number of IPR petitions being filed. And as we'll see as we go through other slides, we'll see that the overall number of challenges have been relatively constant the past 3 years or so. The green graph shows the PGR filings, and red graph shows CBM filings. And again, this reflects a relatively constant number of filings with some minor variations month to month. As reflected by the total number of petitions filed per month, the vast majority of AIA petitions continue to be for IPR rather than for PGRs and CBMs. This next slide further reflects that the bulk of the PTAB's AIA docket consists of IPR filings. The first chart on the top shows filings since implementation of the AIA. As shown, IPRs accounted for about 92% of all proceedings overall, followed by CBMs and PGRs. What we've included on the bottom is a table that shows relative percentage of IPR, CBM, and PGR for the last 3 years. As shown, the total number of IPRs has remained relatively constant, but the number of CBMs has decreased fairly substantially. Additionally, the number of PGRs continues to increase, but still remains relatively small, particularly as to IPR filings. One possible reason for the decrease in CBMs may be the number of parallel district cases where 101 issues have been addressed, and it's possible that it's viewed by litigants as a more favorable forum. But in any event, we are seeing a decrease in the number of CBMs. As to PGRs, I think the increase obviously would reflect the increase in the pool of eligible patents that were issued under AIA rather than pre-AIA, which are ineligible for PGR. The next chart we're showing reflects the total number of district court, ITC, and PTAB cases beginning in 2008 up until last year. And I think there's a few interesting trends reflected in this chart. First, it should be noted about 80% of the AIA proceedings at the PTAB involve patents asserted in counterpart litigation. So 8 out of 10 it's a follow-on typically to a district court or possibly an ITC matter. Only about 20% are just a challenge solely at the PTAB. So accordingly, if you can subtract out the blue matters, which reflect the AIA, the PTAB proceedings, about 80% of that as to the total would be included in what's shown in green and red. And based on that, it can be seen that there's been a fairly pronounced drop in the total number of patent disputes. For example, I understand there was about a drop of about 8% in the total number of patent cases in district court from 2016 to 2017. So I think this reflects a fairly recent trend, consistent trend in a decrease in the amount of patent litigation overall. Second, the chart reflects the fact that the number of PTAB proceedings, again shown in blue, has remained relatively constant in the past 3 years. I think the relative constant number of PTAB proceedings indicates that AIA proceedings will continue to be a popular alternative to district court litigation. On the other hand, the net decrease in district court cases, which again often lead to IPR filings at the PTAB, may potentially lead to a net decline in AIA proceedings at the PTO. Finally, I'd note it may be possible that there may be an increase in PTAB challenges that have not been asserted in district court. Again, that number is about 20%, but countervailing considerations include that the cost of the AIA proceedings, estoppel provisions, and again the clarification by the Federal Circuit that there's a requirement for standing for appellate judicial review. And so based on those considerations, in my view, I think it would be surprising if we saw a dramatic increase in filings where there's no parallel district court case or ITC case. And I'd also note one thing that might lead people to be reluctant to unilaterally challenge a patent without the threat of litigation or of current litigation is the declining institution rate. The slide we have up now shows overall institution rate by fiscal year. I think most people are aware of the fact that there has been a decline, and as shown in this chart, it's been relatively pronounced. The initial institution rate was 87% in fiscal year 13, and it's dropped down to 59% in the current year. Again, it's not entirely clear why the institution rate continues to drop, but I expect that it reflects the fact that petitioners have been seeking to invalidate patents that may be less susceptible to challenge based on prior art than initially when the AIA went into effect. It may also reflect the fact that the board now permits patent owners to include declarations with a preliminary patent owner response, again, which would clearly favor the patent owner and may lead to a decline in institution. In any event, it remains to be seen whether the institution rate will continue to drop or level off around the current rate, which again is about 59%. That's all what I found to be more significant in terms of statistics. I'm now going to briefly cover the two Supreme Court cases that were recently argued and discuss briefly how they may impact PTAB proceedings. The first case that I think is well known to the patent bar is Oil States versus Greens Energy. Obviously, this case may have the most significant impact on IPR proceedings because it involves a challenge to the entire procedure on constitutional grounds. The specific question presented is whether IPRs violate the Constitution by extinguishing private property rights through a non-Article III administrative form without any jury. As we've summarized here, the case was argued November 27th of last year. There's no deadline for a decision, but consistent with historic practice by the Supreme Court, it's expected that the court will issue a decision prior to expiration of the current term, which would be in June of this year. The main argument underlying Oil States' appeal first is whether IPRs improperly wrest invalidity determinations from Article III courts and place them in the hands of administrative judges. Oil States has also raised the issue of whether an administrative proceeding would improperly deprive a patent owner of a right to a jury trial. In response, it's been Green's position and also the position of the PTO, which is defending the constitutionality of the statute, is that Congress has the power to define the limits of a patent grant and may have those determinations made by an administrative judge. Again, in terms of significance, I think it's plain on its face that a decision in favor of Greens would substantially alter the landscape for not just PTAB proceedings, but also patent litigation overall, as discussed earlier with respect to the decline in district court litigation. The other case that was argued the same day as Oil States is SAS Institute versus Joseph Mittal. The question presented here is whether, after institution on any patent claim, the board must issue a final written decision as to every claim challenged by the petitioner. And I think most of us are familiar with the board's practice of limiting trial to specific grounds of institution and not permitting a petitioner to argue invalidity or unpatentability of claims for which there was not a decision to institute. In this case, the Federal Circuit had affirmed the PTAB's practice of limiting trial to certain claims. And as with oil states, we'd expect a decision this term, sometime before June. The arguments involved in this case are relatively straightforward. Summarized in this slide, SAS argues that Section 318A requires the PTAB to address all claims that are challenged in a petition. Here, SAS maintained that position consistently throughout the PTAB proceedings, but the office refused to consider claims for which there wasn't a decision to institute. In response, the PTO has argued that Congress has provided it with the broad discretion to decide whether or not to institute. There's various arguments, but they primarily center on potential inefficiency in forcing the agency to look at every claim, particularly after it decided there wasn't sufficient basis to go forward. Again, I think the significance of this case is fairly self-apparent. If SAS prevails, it may affect the PTO's ability to handle the volume of cases it currently has on its docket. As most of us know, the PTO does have some discretion. It could, in the event that SAS prevailed, undertake other measures to limit its docket and maybe decline more cases on discretionary grounds or based on its workload. That concludes the summary of the Supreme Courses. I'd like to now hand things over to Andrew Cheslock, who's going to first address developments regarding motions to amend.
So this next portion of the webinar is going to focus in large part on procedural issues, the first of which relates to PTAB processes and the manner in which motions to amend by patent owners have been handled at the PTAB, which is a very popular topic based on the difficulty in entering amendments. The Federal Circuit decision itself is rather long. It has a number of different opinions, and there's a lot of text. It is an en banc decision reversing prior decisions regarding the burden that's placed on the parties with respect to the patentability of claims that are submitted as substitute claims in a motion to amend. Given the length of the decision, as we've summarized in this slide, the key part of the decision is put here in the slide, and the Federal Circuit ruled that the PTAB hadn't adopted a rule placing the burden of persuasion with respect to patentability of amended claims on the patent owner that's entitled to deference, and in the absence of anything that might be entitled to deference, the Federal Circuit ruled the PTAB may not place that burden on the patentee. So the decision was issued in October of 2017, and subsequent to that decision, the USPTO issued, the Chief Judge of the PTAB issued some guidance on motions to amend in view of Aqua Products, which is available on the USPTO website. That was issued in November, at the tail end of November in 2017. And significantly, what that guidance states is that in light of the Aqua Products decision, the board will not place the burden of persuasion on the patent owner with respect to patentability of substitute claims presented in a motion to amend. And in that guidance, the Chief Judge provided an example, which is when viewing the entirety of the record before the board, if the evidence is in equipoise or equal as to unpatentability, then the board will grant the motion to amend and allow the substitute claims, ultimately resulting in the issuance of a certificate. In addition, the board noted that generally speaking, the procedure in front of the board relating to motions to amend would remain the same. All of the statutory and rule-based requirements for those motions, including a reasonable number of substitute claims, would remain the same. Subsequent to the Aqua Products decision, there have been a number of decisions by the PTAB in relation to motions to amend, the most interesting of which, to me, was the decision that's summarized on this slide, which is TSMC versus Godo Kaisha IP Bridge 1. In that case, there were 3 substitute claims, 2 of which were found unpatentable over the prior art of record, and 1 claim was found to not introduce new matter, which not introducing new matter is one of the requirements for a motion to amend. And in finding that the new claim or the substitute claim did not introduce new matter, the board focused on the patent owner bearing that responsibility, at least by the way it was written in the text. And then with respect to patentability, the board focused on the fact that the petitioner had not shown that the prior art of record which would demonstrate the unpatentability of the substitute claim. As it stands now, which is reflected by a concurring opinion provided by APJ Fitzpatrick, beyond the guidance that we received from the chief judge of the PTAB, there's not a definitive explanation as to which burdens are borne by which parties with respect to all the different requirements of a motion to amend. And so I found the concurring opinion of APJ Fitzpatrick very interesting, and I would encourage anybody that's interested in this topic to read that portion of the decision. So it remains to be seen ultimately what else may occur with respect to motions to amend and the various burdens of persuasion and production that are placed on the parties by the PTAB. But we do know that the Federal Circuit has stated that the burden of persuasion with respect to substitute claims cannot be put on the patent owner, and the PTAB is currently, by way of its guidance, applying that practice. So the next topic that I'd like to discuss is additional discovery in PTAB proceedings. As we all know, discovery, the concept of discovery in U.S. District Court and ITC litigation is very wide-ranging, and it is, of course, not the same in the AIA context. So in the AIA proceeding context, we do have a concept of discovery, but the discovery that is typically taken during an AIA proceeding is the cross-examination of declarants. And so typical practice is there's a cross-examination in the form of a deposition of the experts for the petitioner and the patent owner. Beyond that, what's called routine discovery, there is a rule for additional discovery, and there are a number of decisions in 2017 that I found instructive to indicate what the PTAB will or will not allow in terms of additional discovery, because you have to seek leave from the PTAB in order to obtain that discovery. The factors that go into the decision are these Garmin factors that have been in place since March of 2013. I think many of us are probably familiar with those. So the first PTAB decision that I found interesting was the Mylan versus Allergan decision. One thing to note, this particular decision is applicable to a total of 6 IPRs, but we only included one of the IPR numbers in terms of the space. But a total of 6 IPRs, but we only included one of the IPR numbers in terms of the space. But if you're interested in finding this decision, you can still find it using that number. So here we summarize the issue in this slide. But the main issue here is the board is interested in allowing additional discovery in circumstances where it would actually impact any decision on unpatentability. And so in the first circumstance, certain discovery was allowed because information with respect to certain of the figures in a reference were not available, and the requested discovery would provide that information to the petitioner to allow them to fully articulate the reasons why that reference was applicable. And then correspondingly, there were other requests where the figures in the reference did have sufficient information, and so on its face, that information was available to the petitioner, and it wasn't necessary in the PTAB's mind to allow for additional discovery of the underlying information. So that's one type of example where you're focused on perhaps data or underlying information in reference to some particular evidence that might be submitted in the current record of an IPR. The second decision, Mylan versus Qualicaps, I found it interesting because the patent owner relied on a declaration that was provided by the inventor of the patent at issue that was submitted during the original prosecution. And that declaration was used as evidence of unexpected results. Here, the inventor had been previously deposed in the co-pending litigation. In this circumstance, the petitioner was seeking not only an additional deposition of the inventor, but also a wide-ranging document request of all documents in patent owner or the inventor's possession, custody, or control supporting or refuting the patent owner's assertions regarding unexpected results. Ultimately, what the PTAB did here is they declined the additional deposition. They allowed entry into the record of the transcript of the inventor's deposition as he had been designated as a 30B6 witness, and one of the topics was this issue of unexpected results. The PTAB declined to order production of all the documents, but did allow certain of the documents that related to, allow discovery of certain of the documents that related to certain of the underlying experiments, data, and statements in reference to that inventor's declaration. So I found that interesting, not only because of the way in which the PTAB sort of ultimately narrowed the petitioner's request, but also how it could relate to circumstances where there's co-pending litigation and there's evidence from that co-pending litigation that a party may wish to include in the record of an IPR and AIA proceeding. The third example decision from 2017 addresses a slightly different topic. Here, it's also related to co-pending litigation, but in this circumstance, it related to a request by the patent owner for certain documents that were referenced in an initial determination from an ITC proceeding. In this circumstance, which I found interesting, the PTAB recognized the existence of the protective order, but also recognized that many of the documents were actually petitioner's own documents and not a third party, and so for that reason they were in their possession and control, and in relation to the secondary considerations of non-obviousness issue. The next procedural issue, which is new, relates to a standard operating procedure that the PTAB recently issued with respect to decisions where cases are remanded back to the PTAB after a Federal Circuit decision. These standard operating procedure number 9. The link is here in the slide, so you'll be able to access that when we publish the materials online. It was issued in November of 2017, so just over 2 months ago. And it provides a series of guidance not only for the parties that are involved in an AIA proceeding that has gone to the Federal Circuit and been remanded. It also provides guidance to the board itself in terms of the various meetings and discussions that need to take place between the panel and the chief judge of the PTAB or the deputy chief judge. Some of the requirements here we've summarized on the slide, including the need to contact the board following the issuance of a mandate after a decision, and the fact that the parties, consistent with existing practice prior to contacting the board, should meet and confer to try and reach agreement on the various issues, and potentially also the need for any additional briefing or submission of additional evidence. On this slide, we've summarized some additional information about what the guidance says. The goal here for the PTAB is to deliver a decision within 6 months after the following remand. There's a goal of having the phone call with the board within a month. And as far as the issues that the board anticipates the parties should meet and confer about prior to that phone call, there's a listing, most of which is not surprising. The first of which includes, additional briefing in the subject matter of the types of briefing schedule, and whether or not supplemental evidence is going to be needed in view of the remand. The guidance also provides some indication as to what will ultimately happen following a remand, and so examples include whether or not there would need to be additional briefing for claim construction issues, the fact that it's unlikely for new evidence to be introduced into the record, absent a showing of good cause, and the fact that additional oral argument beyond the original merits hearing is unlikely, and usually only unless new evidence has been submitted in the record that would need to be discussed in such an oral argument. The guidance also includes this table that we've reproduced on this slide that goes through various different remand scenarios and then indicates the existing guidance as to whether or not there would be additional briefing, additional evidence, or additional oral argument. Of course, this is just guidance, and so things could change, but this is what the PTAB currently envisions, an example of which is the first one, erroneous claim interpretation. So there would likely to be additional briefing with respect to the terms that are at issue, but unlikely to be any additional evidence or any additional oral argument. So the last piece that I'd like to discuss relating to procedural issues is developments in the ability of parties to appeal decisions of the PTAB to the Federal Circuit. And in particular, a recent case that was issued in actually a little over a week ago in January 8th of 2018. This case relates to whether or not a party, in this case the patent owner, can appeal to the Federal Circuit with respect to the one-year time bar provision that's resident in Section 315. The decision is based on the statutory language that's in 314. And in particular, the fact that the statutory language says that the decision is non-appealable, and in particular, under this section shall not be final and non-appealable. And so in coming to their decision, they focus primarily on Section 314, and in particular, the language of 314A that relates to the likelihood that the petitioner would actually prevail with respect to at least one of the claims. And so the court ultimately decided that given the strong presumption of judicial review and the language that in 314 that the non-appealable language did not prevent the patent owner from appealing the one-year time bar issue. The Federal Circuit specifically noted that that was the only issue that they were deciding, and they left open the issue of whether or not any of the other requirements of the AIA, and in particular the IPR statutes, could be appealable. But so in that respect, there may be further developments with respect to denial of institution and other requirements that are part of the statutory framework. So now I'd like to turn things over to Steve Mabius, who will start with a discussion of trends in pharmaceutical IPRs filed by generic petitioners.
Well, thanks, Andrew. Hi, everybody. This is Steve Mabius, and as Andrew mentioned, I'll cover our last two topics, which will be trends in pharmaceutical IPRs filed by generic petitioners, as well as some recent developments in sovereign immunity. So this first slide is to summarize a little bit about the background of what we did in terms of examining this area. And we looked at a total of 204 IPRs that were filed by generic petitioners. And this is by no means all of the IPRs that were filed by generic companies, but I would say that it's a pretty substantial percentage of the total. And we utilized some of the larger generic company names as petitioner to acquire the sample that we used in our study. And we looked at the institution rate specifically in this subset of IPRs and found that it was about 75%, which is significantly higher than the institution rate reported for the biopharma category of the USPTO, which is really a larger category of IPRs that, goes way beyond just generic IPRs. It includes other types of chemical patents and biotech and DNA analysis, things that aren't really in the pharma space, whereas the IPRs that are being filed by generic companies are focused on pharmaceutical products and really commercial aspects like formulations and methods of treating disease utilizing active pharmaceutical ingredients. So it's quite a bit higher, at least compared to the 63% institution rate for that larger category identified by the PTO. Now, there have only been about 41 IPRs. This is as of May 2017 last year, so there's certainly been more since the time that we did this study. But at the time we did it, there was 41 within our sample that had actually reached the final decision. So it's still a relatively small sample size in terms of actual final written decisions. But we determined that all claims were found unpatentable in only 59% of those IPRs, which is, I think, significantly lower than the overall 67% invalidation rate for instituted claims that's reported by the USPTO in the biopharma category. One reason for that may just be the unpredictability that's associated with pharmaceutical invention and the fact that a significant amount of evidence can be introduced by patent owners post-institution to respond to whatever grounds of unpatentability are instituted on. So even though there's a higher rate of institution, there's this, at least what appears to be, a lower rate of invalidity finding in the sample that we've analyzed so far. Another key point is the high rate of settlement. And I think that's significant because what it means is that a significant number of these generic filed IPRs are being taken off the table before they reach a final written decision. So it could be that some of the more stronger cases are being settled, and therefore we're not actually seeing final written decisions because of the settlement. So the settlement is at about 22%. That's the combined pre- and post-institution number. If you look only at pre-institution settlement, it's about 14%. Another interesting point is that 28 out of 44 settlements in our sample related to parties that were litigating multiple related patents. In other words, patents that were associated with a single commercial pharmaceutical product and various litigations relating to that product. So in many cases, there were group settlements when one party settled and various generic IP filers who had filed motions for joinder were joined in. They had a seat at the settlement table, and so they were able to reach a settlement as a group. And that's one of the benefits of potentially using a motion for joinder in these situations, is to try to get access to potential settlements. There's also a high rate of parallel litigation associated with generic IPRs, not surprisingly. Out of the 205, we looked at 73% involved a parallel litigation where the IPR petitioner was a defendant in at least one of the litigations associated with the patent. There were often multiple parallel litigations, as I mentioned, which commonly happens when there are first, second, third ANDA filers who may decide to join into IPRs that were filed previously, and sometimes they file a very similar IPR petition or just seek to be joined to an existing IPR. In other cases, they have distinct prior art and end up filing a separate IPR that may not be merged into the other proceedings if the grounds of unpatentability are distinct enough. In still other cases, defendants may choose not to file IPRs or join in. And one area where you sometimes see that is with the first ANDA filers who may prefer not to pursue IPR in order to avoid any issues associated with forfeiting the 180-day exclusivity associated with being a first filer. This next slide highlights the choice of IPR counsel in situations where there's parallel litigation. With respect to pharmaceutical patent owners, in the sample that we looked at, 43% chose to involve an additional firm other than the litigation firm in the IPR proceeding, and about 26% included litigation counsel in the IPR, but 17% did not ever have litigation counsel enter an appearance in the IPR. And one potential reason for this is the prosecution bar that is sometimes contained in protective orders in the parallel Hatch-Waxman litigation, depending on the language in those protective orders and also depending on whether there is a possibility that the patent owner may choose to pursue a motion to amend. It can sometimes make it easier to sort of create a wall when there's a separate law firm involved as IPR counsel, and in order to make sure that there's no disclosure of product-related information that's barred under the protective order in cases where a motion to amend might be pursued. I have seen at least one case where after the patent owner agreed that it would not file a motion to amend in an IPR, the generic petitioner agreed to allow the parallel litigation firm to participate actively in the IPR as co-counsel with another firm that had been brought in to handle the IPR. And then about 57% of patent owners ended up using the same firm for both the parallel litigation and the IPR. As to the petitioners, about a higher percent, 64%, chose to involve an additional firm in the IPR, and then 35% of those included their litigation counsel as co-counsel in the IPR. 29% did not list litigation counsel at all in the IPR, and then the 37% used the same firm for both. This slide here just indicates the relative level of IPRs filed by generic companies. And these are you see that Mylan has filed a very significant number of IPRs, and there are a number of others who have filed them as well. So that just gives an indication of how active certain companies are in filing IPRs against pharmaceutical patents. This slide here is just a visual depiction of the outcomes of these generic filed IPRs. And you see that there's a significant number that have been instituted but have not led to a final written decision. That's the tallest blue column in this chart. And then the next tallest blue column is the number where there was no institution. And then you see the various other outcomes, some with all claims found unpatentable. There were 24 days, as I mentioned earlier, and then 16 where all the claims were found patentable in the final written decision. Then on the right-hand side, you see the post-institution settlements and pre-institution settlements, and then certain other cases where they were terminated without settlement for reasons such as request for entry of adverse judgment or disclaimer of the claims that were subject to the IPR. So now I'd like to switch topics to sovereign immunity of state-owned patents and patents owned by other entities that may qualify for sovereign immunity. One of the early cases that address this question is Covidian versus University of Florida Research Foundation, where there was a patent owned by University of Florida Research Foundation, which is basically the IP arm of the University of Florida. And this is a case where the board had to confront the issue directly of whether or not there was immunity because of the fact that the patent was owned by essentially an arm of the state government of Florida. And in this case, the board did conclude that UFRF was entitled to sovereign immunity, and therefore they dismissed the IPR after finding that UFRF did constitute an arm of the state entitled to sovereign immunity. And I think what this case does highlight is that you have to look pretty carefully at the details of who is the actual owner of a patent, and is that owner, whatever entity it is it really an arm of the state government, or is it somehow separated from the state government in a way that makes it more of a private owner? So following that case, there was another case involving University of Maryland, who was asserting 11th Amendment sovereign immunity with respect to an IPR filed against its patent. And the petitioner argued that there was waiver of immunity simply because the University of Maryland had obtained the patent and also licensed the patent. And in addition to that, they were participating in the IPR proceedings to defend this patent. So they argued that that constituted a waiver. The PTAB found that this is not a waiver of immunity, and they further didn't agree that the IPR could only proceed if Maryland brought in its licensee, because Maryland had retained rights under its license to handle proceedings like IPRs and therefore was a necessary and indispensable party. Another case is Surface Limited versus Toyota Motor, where the patent at issue was co-owned by Toyota and University of Minnesota. University of Minnesota was not actually named as a party in the IPR, but the PTAB agreed that the university could not be compelled to join against their will, but yet the proceeding could continue in their absence. Toyota and the university were co-owners, and therefore they held identical interests in the patent. They were represented by the same legal counsel, and on these facts, the PTAB determined that the IPR could proceed because Toyota, the co-owner, obviously wasn't entitled to sovereign immunity. Much more recently, we had two cases involving the same panel, LSI Corp. Versus Regents of University of Minnesota. So here again we have University of Minnesota, except this time they were the sole owner of the patent. And then there was another case, Erickson versus University of Minnesota. And the nearly identical opinions found, and this was also an expanded board panel, they found that the patent owner in this case had waived its 11th Amendment sovereign immunity by filing litigation proceedings in federal court alleging infringement of the patent that was being challenged in the IPR. And so this case stands for the proposition that there can be a waiver when universities actually choose to litigate their patents in district court. So the other case found that licensing a patent by itself is not enough to trigger a waiver of immunity, but litigating in district court will lead to a waiver of immunity for patents that would otherwise be immune.
At this time, I'm going to read the CLE code for this program. If you are in need of CLE credit today, please enter this 5-digit code into the poll question on the screen after it is announced and press the submit button. The code is JSFNN. That is J as in Jacob, S as in Sally, F as in Frank, N as in Nancy, and N as in Nancy. JSFNN. Again, if you are seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. For those seeking Kansas, New York, and New Jersey CLE credit, in addition to the polling question, you will need to complete the attorney affirmation form and return it immediately following the program. A copy of the form can be found in the resource list widget. As a reminder, certificate of attendance will be distributed eligible participants approximately 8 weeks after the web conference via email. At this time, the poll is now closed. I would like to return the program to our speakers.
So I'd like to finish up with our final topic, which is sovereign immunity in the case of transfers to Indian tribes. The case that really started this trend is Mylan Pharmaceuticals versus Allergan. And this was a case where during the course of IPR proceedings relating to 6 Allergan patents, the owner, Allergan, entered into an assignment agreement with the St. Regis Mohawk tribe that included an exclusive field of use grant back to Allergan, as well as various provisions that involved in basically investing in the St. Regis Mohawk tribe and providing some benefits to the St. Regis Mohawk tribe as a result of the agreement that they were entering into. The tribe asserted that it was an indispensable party after the transfer occurred and filed a motion to dismiss the IPRs based on asserting sovereign immunity over these patents. Mylan, the petitioner, argued in response to this motion that the transaction was really just a sham and that the patents shouldn't be shielded from invalidation during the inter-parties review based on this agreement. The PTAB decided to authorize the filing of amicus briefs. I believe a total of 15 amicus briefs were filed, and the parties, Mylan and the tribe, filed responses to those amicus briefs pretty recently on December 15th. And the time for entering a final written decision has now been extended to April 6, 2018. Meanwhile, there was separate litigation between Allergan and Teva in district court in Texas, where certain claims of the 6 patents at issue in the IPRs were found to be invalid as obvious over prior art. So that litigation had not been stayed pending the outcome of the IPRs. The court did issue an opinion with respect to the addition of the tribe as a co-plaintiff in that district court action, and stated that they felt that the motivation for the assignment was an attempt to avoid the IPR proceedings, and the court had serious, quote, serious concerns about the legitimacy of this tactic. It's not clear how this case is going to turn out in the PTAB, but they are going to enter a decision in the next few months. Meanwhile, this practice of transferring to entities with sovereign immunity has now spread beyond the pharmaceutical area, and this next slide relates to a situation where there's an IPR between Apple and MEC Resources LLC, and the patent relates to an inductor, which is an electronic circuit component, and the patent owner who recently filed its mandatory notices indicated that MEC is a tribal limited liability company wholly owned by a certain company that in turn is a wholly owned subsidiary of 3 affiliated tribes of the Fort Berthold Reservation. The patent owner also filed notices requesting a stay pending its motion to dismiss for lack of jurisdiction based on sovereign immunity. So far, the PTAB has not yet authorized a motion to dismiss in this case, so we'll have to see what happens next and how it comes out. And with that, we're at about the end of the hour now, and if there are any questions, we'll try to answer them in the short time we have remaining. Thank you for your attendance.
Steve, this is Andrew. We do have a question, and I'll just read it out and maybe you can address it. It's how broad is the waiver of sovereign immunity? Is it for that patent and related subject matter, or is it broader?
Well, that's a good question, and I'd invite Andrew and George to comment as well. I don't think the waiver would extend beyond the patent that was litigated. I think it's specific to the patent at issue in the IPR, and at least based on these first cases, it doesn't seem like the board would have to answer the broader question and would probably choose not to answer more broadly than they have to. But Andrew or George, do you have any comments you want to add on that?
This is George. I would imagine that there at least be the argument that waiver is disfavored and should be strictly construed. So I would expect at least it'd be an argument that the default should be to limit the scope of the waiver as much as possible.
Yeah, one of the things
issue that needs to be worked through.
One of the things I recall that was noted by the board in its rationale for those decisions where they found the waiver was they pointed out that the AIA creates this option for defendants in litigation to bring an IPR within 1 year of being served with a complaint. And I think they kind of linked the waiver, to some extent, they linked waiver to that provision in the AIA, which suggests that it's patent specific.
Okay. Looks like that's the only question we have. Okay, well, thank you for attending today's webinar. If you have any further questions, George, and Steve's contact information is provided on this slide, and we'd be happy to answer any further questions that you have.